Welcome to HyBiz News. My name is Suresh Kocharan. A US court has lifted the stay on Devas' plea for compensation from Antrix for cancelling a deal. The US court has lifted a stay on the proceedings of a lawsuit filed by the Bengaluru-based Devas Multimedia seeking a compensation of $1 billion from the Indian space research organization commercial arm Antrix Corporation for cancelling a satellite deal in 2011. In his order dated September 17, Judge Thomas S Zilly from the U.S. District Court, Western District of Washington, lifted the stay on the proceedings of the lawsuit filed by Devas against Antrix. The court has scheduled October 14th as the next date for hearing by Zoom, a virtual meeting platform, to determine whether Devas' lawsuit against Antrix be granted to proceed ahead or dented. In 2005, Devas Multimedia had entered into an agreement for lease of space segment on the capacity of Antrix S-band spacecraft. According to the agreement, Antrix agreed to build, launch and operate 2 satellites and make available 70 MHz of S-band spectrum to Devas, which later planned to use the hybrid satellite model and terrestrial communication services throughout India. In February 2011, Antrix terminated the agreement. Over the next several years, Devas approached various courts and legal avenues in India. This included the Supreme Court, which directed for a tribunal to be appointed. The tribunal in New Delhi, in its order dated on September 14, 2015, concluded that Antrix wrongfully repudiated the Devas-Antrix agreement. The tribunal also asked Antrix to pay $562.5 million to Devas for the damages caused by Antrix's unlawful repudiation of the agreement, along with pre- and post-award interest rates, which crossed the compensation to more than $1 billion. In its lawsuit filed in the US court in September 2018, Devas said that 3 separate international tribunals and 9 different arbitrators have found the termination of the Devas-Antrix agreement to have been wrongful, with one of the tribunals describing as a conduct which shocks or at least surprises a sense of judicial propriety, and another finding it to be a clear case of breach of simple good faith by India. Antrix in November 2018 had sought the dismissal of the lawsuit citing jurisdictional issues. The court, however, asserted that it had jurisdiction on the issue but stayed the matter for 1 year and asked 2 to file a joint status report by 15th of April 2020. On 16th of July 2020, both Devas and Antrix filed the instant motion, a joint status report, in which they disputed whether the court should lift or extend the stay, and, if the latter, whether Antrix be required to post security. Judge Zilly, in his order, noted that more than 5 years have passed since the tribunal award was issued, and nearly 10 years have passed since the contract was disputed. Likewise, the stay was entered more than 1 year ago, and there have been no new developments in the Indian courts on the jurisdictional issue or on the merits of the proceedings, he said. Devas, according to the submissions, have argued that the US court has a jurisdiction over 3 cases as Antrix engages in the business in this district and across the United States. Antrix, in its submission, asserted that this case involves purely foreign dispute with no connection to the United States. Both parties are Indian corporations. The underlying contract was governed by the Indian law and called for performance in India. All the events giving rise to the dispute occurred in India, and resulting arbitration was seated in India, it said. Antrix has no offices, employees, bank accounts, or agents in the United States. Antrix's few sporadic business dealings with US companies are completely irrelevant to the exercise of jurisdiction over Antrix. It asserted and sought dismissal of the court case. Antrix asserted that as per the agreement of January 28, 2005, it agreed to build, launch and operate 2 satellites and lease certain S-band spectrum frequencies to Devas. In exchange, Devas agreed to pay certain upfront capacity reservation fees and annual fees from $9 million to $11.25 million. The implementation of the agreement was subject to obtaining various government and regulatory approvals and clearances, it said. Under the agreement, Antrix could terminate the deal if it was unable to obtain the necessary satellite orbital slots. In the event of an early termination, the agreement limited Antrix's liability to the reimbursement of any upfront capacity reservation fees which was paid by Devas at the date of termination, it asserted. Noting that the agreement provided Devas with a lease of approximately 37% of the total S-band spectrum allocated to India by the ITU, Antrix told the US court that the implementation of the agreement was essentially doomed from the start, given the competing and growing requirements of the Indian government to use the nation's limited S-band spectrum for military and national security purposes. Antrix told the court that the termination of the agreement was based on the decision of the Cabinet Committee on Security on 17th of February 2011. The Cabinet Committee on Security concluded that because of the growing need for S-band spectrum for military, national security and societal uses, the Indian government would not provide Antrix with an orbital slot for commercial activities. In view of this conclusion, the Cabinet Committee on Security decided that the agreement should be annulled, Antrix told the US court.